Okay, so welcome to this morning's webinar, Home Education with Contact Cymru, and our guest speakers are Gov Carr, who's an associate solicitor at Irwin and Mitchell, and Beth Parr, who's a solicitor at Irwin and Mitchell, and also Nicole. And Nicole, I can't remember your title, sorry. Is it Business Development?
That's all right, yeah, that's right.
Oh, thank you. And I'm Kate Wyke, so I'm manager for Contact, and we are a charity for families of children with additional needs. After today's session, I will send you a link to the recording. I'll also send you some other information about what we can offer you at Contact. And we support families of children with all kinds of different needs, right from the age, well, from before birth up to the age of 25. So hopefully you really enjoy today's webinar, but also that we can keep in touch. So I'm going to hand over now to Gov, who's going to begin the webinar.
Thanks, Kate, and good morning, everyone. Thank you for taking the time to join us today. My name's Gov Carr, as Kate said, and you may be able to see a camera on from my colleague Beth Parr. I head up the education team at Irwin Mitchell. We are solicitors, and we as a team specialise in all matters education. We have a particular focus on special educational needs, additional needs, and really all and every aspect of education. So running through from admissions and exclusions through to the SEN or ALN side of things as well. I've specialised in education work for 14 years now. Beth has got a few years less than me. But the thing about education is it's so immersive that you build up really quite an experience. Thank you for Contact to asking us to come in today and deliver the session. And for the purposes of today's session, Kate, you'd asked us to cover really issues surrounding, well, home education or elective home education as it's technically known. Hopefully you can all see the slides on show. I do believe they're going to be circulated to you after the event. Kate, pull me up if I'm wrong on any of this.
That's correct.
So please don't feel that you need to necessarily sit through today's session and furiously make notes. Really, it's a case, I would say, of trying to take in any information that we give you. The slides are there as a visual aid. You will get them circulated afterwards. I'm sure you'll all be aware, as we've all become quite accustomed to Zoom over the past couple of years. There is the chat facility. So can I suggest that if you've got any queries and questions, that you put them in the chat. We're going to monitor the chat throughout today's session. Hopefully towards the end of the presentation, we will be able to answer some of the queries. We'll get through as many as we possibly can, and for any that we're not able to get through in the time allowance that we've got today, we will perhaps look at putting something together by way of an email response and get that circulated. So just so that you're aware that if you do have questions, I realise with it being on the record and no cameras on and the mic's muted, we will try and take account and answer as many questions as we possibly can. That's all the housekeeping then from my side. We will jump straight into the presentation now then. So in terms of the areas we're going to cover today, I'm going to talk to you first of all a little bit about elective home education itself, what that means, what you can expect to be doing in that sort of circumstance. The very necessary and obvious thing to talk about as well is the relationship between wanting to electively home educate and having special educational needs or additional learning needs, as they're now being described under the new system that's being rolled out in Wales. So you'll see on the slide there's a reference to SEN or IDP. That references to statements of special educational needs as they are under the old or current system, IDPs being the individual development plans that are being rolled out at the moment and are going to be the system going forward. So we'll talk briefly about the relationship between those two and what your rights are in terms of having a child with additional needs, special educational needs, and wanting to home educate. And then Beth will be talking to you a little bit more about that relationship between alternative education, i.e. non-school-based education, under the new education, the new ALN system being rolled out in Wales. Kate, can we go forward in the slides then, please? Thank you. So at the top of the slide there, you will see what I will basically describe as, or a definition of what elective home education is. And it's parental choice, and I really can't emphasize that aspect of the description enough. You'll hear me come back to that quite a few times as we go forward in today's discussions. But it's parents choosing to educate their child at home instead of school. So you may be aware that legally there is a requirement for children to receive education, but actually there is an element of choice and discretion from a parental perspective as to how that is going to be received or delivered to your child. You may choose to enter them into the school system, and that's the obligations on local authorities to have placements available and so on and so forth. But equally, you have the choice to be able to say, actually, I want my child to be educated, but not through the school system. I've put on the slide there for you some of the reasons, and this isn't an exhaustive list, just some of the situations and reasons why parents may choose to electively home educate their child. It may be based upon a belief system that you have. It may be that you feel that actually a flexible or non-school based education system is a better learning style for your child. Whether or not that's based around some special educational needs, additional learning needs, or just favoured learning styles, as simple as that. You may also decide to electively home educate your child because you do actually want them to go to school at some point, but the school that you want for them isn't able to offer a place at the moment. So instead of sending your child to a different school for a period of time, you actually decide that you want to educate them yourself, electively home educate, and at some point send them into a particular school. I think all of that really comes down to freedom of learning. Certainly in terms of the Welsh Government, there is lots of guidance out there that talks about elective home educating being available to allow parents the freedom to be able to allow their children to learn how they want. So there doesn't have to be a condition as such. It is very much your choice as a parent to do that. It's why it's also important to bear in mind circumstances where elective home education shouldn't be used. And I've put on there at the bottom of this slide, it should not be used by a school or a local authority to avoid or be suggested as an alternative to excluding your child or prosecution. That prosecution reference there, some of you may be aware that there can be a criminal prosecution or a fine given to parents in relation to non-attendance of their child or regular non-attendance, unauthorised absence. So that's what that reference to prosecution is. And exclusions, well, whether they are fixed term for a certain number of days or indeed a permanent, where we're talking about it being a permanent decision to remove the child from a school. And that really, I think, is quite a common sense comment to make, really, if you think about what I said at the outset about elective home education being parental choice. That circumstance there is very much about it being forced or imposed upon a parent as an alternative. I think the other circumstance to highlight to you where elective home education shouldn't be put forward is where, again, a local authority is suggesting to you that they are unable to provide either a particular school place that is able to meet your child's needs or a particular part or package of provision that is able to meet your child's needs. Again, that's not using elective home education as it should be in terms of it based on your choice of educating your child. It's rather being imposed upon you, and it's really important that you understand that distinction between it being a choice, not an imposition. If we can move on to the next slide, please, Kate. Okay, so we've set out here for you what the requirements are. These are requirements on the parent we are talking about for the moment. We'll move on in a couple of minutes to talking about the local authority and their involvement in an elective home education scenario. I've given you the reference there to the legal basis upon which parents can electively home educate. That's Section 7 of the Education Act. The requirement on parents in providing that home education is for it to be, and the key terms there are, it's got to be efficient and suitable education, and it's got to be suitable. And that suitability is determined by looking at the age, aptitude, ability, and special educational needs or additional learning needs as now described under the new process of the young person. So there's still, although I say it's a requirement, there's an element of flexibility built into that, because we are taking into account those very individual circumstances of the child and the learner, that being their age, their aptitude and their ability, and any difficulties that they may face in being able to access that education. One of the really key things to bear in mind before deciding whether elective home education is a route you want to go down is that if you are electively home educating, because it is your choice to do so, you as parent will become entirely financially responsible for all or any costs of educating your child under your elective home education programme, whatever that looks like. That also includes, and I've put on there, the cost of any public examinations. So where you are electively home educating, there's no requirement on a child to follow a particular formal examination route. It's not a requirement, for example, to follow and take GCSEs. But you may decide as part of your elective home education programme that you want to follow a GCSE programme. You can arrange for your child to enter those examinations. What you can't do is say that it's for the local authority or a particular school to foot the bill of that. You would be financially responsible for it. I should say some local authorities choose to have some levels of fundings or grants or resources available to families that electively home educate. That is not a legal requirement on them to do so. That is just something that they may have locally decided they want to do. What I would suggest you do is just do a little bit of investigation or digging around your local authority website, maybe look for some informational pages on elective home education, and that should point you in the direction as to whether your local authority does offer any support, whether that's in terms of resources, discussion groups, or indeed access to some sort of facilities in relation to elective home education. But it is important that you remember that it's not a requirement on them to do so. We've talked about what parents need to do by way of requirements. It's also important, I think, to highlight what you're not required to do when you're electively home educating. So you are not required to follow the national curriculum. Again, that's a system of education, if you will, that's set out in schools. Again, similar to the point of GCSEs, if you wanted to follow national curriculum, you're absolutely within your rights as an elective home educator to go out there, get that information and implement a programme of learning at home that is based on those principles, but you wouldn't be required to follow that. You couldn't be penalised for not following a national curriculum type education system in your elective home education programme. You're also not required to register or seek approval from your local authority to electively home educate. There is one slight caveat to that where we're talking about a child or a young person that has a statement of special educational needs or an IDP, the Individual Development Plans under the new system. We'll come on to that in a little bit more detail. But generally speaking, unless you are outside of the bracket of having that document of SEN attached to the young person, there's certainly no need to register or get approval or authorisation from a local authority to electively home educate. It is your right to do so. You're also not required to be a teacher or have a teaching qualification as a parent to electively home educate. I've put a can list there in terms of there are some discretionary things that you might want to think about. We've already touched on the first one about choosing to enter into formal examinations. You can choose to do that, but there's no requirement on you to do that. It's also important to bear in mind that you will still have access to, or rather your child or young person will still have access to all of the health services that you might normally see them have access to through school. And the way that you'd go about getting that access is essentially a health referral. So you'd be going to your GP and you'd be making appointments for example, immunisations, on the basis that your child won't be called in for any kind of routine programme that might be rolled out in a school. And you wouldn't have an issue accessing that. It would just be through the typical health referral route. It's also important to remember that with elective home education, you can come in or out of that system at any point that you choose to. So it is not a case of saying that if your child has entered into a school attendance arrangement, so your child's attending a school, and you then decide 6 months down the line, 3 years down the line, that actually you'd like to electively home educate them, you can choose to do so. You have a right to do that. Equally, if you've electively home educated your child for a period of time and then decide you want them to return to school at a point, you are entitled to do so. We will cover the process of doing that in a couple of slides' time, but it's not something when you're elective home educating that you are committed to for the duration of your child's educational career. Kate, can we move forward? So the role of the local authority in electively home educating, because I suppose the thought of many parents is, well, if I'm electively home educating and taking my child out of the state system, why should there be any input from my local authority in relation to what I'm doing? The reason that we can expect input from local authorities in the arrangement is because the right to electively home educate is a conditional one, and that is conditional on parents providing efficient and suitable education. We talked about that being a requirement of the education previously. There's two particular legal points and legal duties on local authorities that require them really to have a level of investigation and input into children that are electively home educating, and I've set them out for you on that slide. There's a duty on local authorities to make arrangements to identify children not receiving education. That's not to say that a child that's being electively home educated isn't receiving education, but it would fall into a bracket of perhaps a local authority wanting to identify categories of children and how they're being educated. There's then a further duty on local authorities also set out for you there, where a local authority is required to take action if it appears that parents are not providing a suitable education. Again, going back to that requirement of elective home education being suitable. If there's a duty on our local authorities to take action if education is not suitable, it follows therefore that there's going to have to be a level of investigation or assessment of the investigation that's being provided. Okay. I would describe the process of local authorities doing that investigation, and I've set that out on the slide there for you. Suggestion would be that a local authority might make a home visit or have some level of contact with a parent, draw up a plan of action of what the suitable education needs to look like, and then set out a series of timeframes as to when those steps need to be met. You would then allow those timescales to be achieved, and then do a further assessment and say, okay, well, we raised concerns about this education programme not being suitable. We came up with a plan of action. We had a time frame of looking at whether within that time, taking those steps, you've been able to make your elective home education programme suitable. And one would hope that the programme was determined to be suitable at that point. But if it wasn't, then the local authority might take steps to move things forward and look at securing a school attendance order, which they're entitled to do. And a school attendance order is essentially an order from the council requiring the attendance of a child at the particular named school within the order. Parents would then have a certain number of days within which to either ensure that the child is registered at that school or be able to evidence that they're providing suitable education. However, there will have been that process that has been pursued by a local authority to investigate and look into what suitable education would look like. Can we go forward in the slides, Kate, please? If you wanted to electively home educate your child, then what's the process that you would go through to do that? Well, there has to be, the requirement on parents is for there to be written communication, so written notification basically, to the head teacher of the school that your child is registered at, and you're asking in that letter, all you're asking the head teacher to do is deregister the child from the school for the purposes of elective home education. What the head teacher will do with that notice then is notify the local authority within 10 days. And then you can expect the local authority to be in touch with you to say, we've been notified by X school that your child is now being electively home educated. That's essentially the process that you have to go through, and it ties into what I said originally about there not being any need to seek authorization or permission to be able to electively home educate your child. It's important to say, of course, that if your child has not entered the school system, that is, if your child has not ever attended a school, so if they're around that 5-year mark and haven't gone into school yet and haven't been registered at a school, then there is no notice that has to be given to a head teacher of a school. So the requirement to give this notice is only in relation to a child that is registered at a school. So you must give notice if your child is registered at a school. You do not need to give notice if your child is not registered at a school. We talked a couple of minutes ago about the right to be able to dip in and out essentially of elective home education. So you might electively home educate for a period of time and then decide you want your child to go back into the state system or to attend a school. If you wanted your child to return to a school or any school, what you need to do is give written notification of that fact to the admission authority. And what we mean by the admission authority is whoever is responsible for arranging the admissions to that placement. That can differ. So in some circumstances, a local authority is an admission authority. In some circumstances, the school itself will be the admission authority. It will come down to the type of school it is that you are looking at. So whichever, the easiest or the most straightforward way to do it really would be to just contact the particular school that you are wanting to look to get your child registered at, put a call into them, say that you want to register your child at the school, and the school will tell you themselves who the admission authority is, whether you need to contact them or the school. Can we go to the next slide, please, Kate? Elective home education for children with additional needs or special educational needs, specifically where you have a statement of special educational needs under the old system or an IDP, an individual development plan, under the new system. I've mentioned this new system in ALN a couple of times now. Many of you may be aware of what I'm talking about. For those of you that are not, Wales is in the process of rolling out a new additional learning needs system, which replaces the previous or special educational needs system. Under the old special educational needs system, you could secure a statement of special educational needs, which is a document produced by the local authority, maintained by the local authority, which sets out a bespoke package of support and provision that is tailored to the young person's special educational needs. Those documents under the new system are going to be replaced with a document called an IDP. However, there is a 3-year rollout period to transfer from the old system of statements into the new system of IDPs. So as it stands at the moment, and I believe until sometime in the end of 2024, we will in Wales be basically we'll have a mix. We'll have some young people that have statements and some that have IDPs. Obviously, the idea over that period of time is we will move a larger and larger percentage across to the IDP system. So just for your reference, the information that I've put on here where there is reference to a statement of SEN, if you are a young person or if you're responsible for a young person who has transferred onto the new system or has under the new system been issued with an IDP, any reference to a statement of SEN applies equally to an IDP. Where we have a young person with a statement or an IDP, the only distinction in relation to elective home education is the type of placement that they attend. So the first thing to say is just because your young person has a statement of SEN or an IDP does not prevent you in itself from being able to electively home educate. You still have the right to choose to electively home educate your child if they have a statement or an IDP. However, the process that you will need to go through to be able to arrange that will differ dependent upon the type of placement that your young person attends. That's why I put those two distinctions on those slides there. So if your young person with a statement or an IDP is attending a mainstream school, so that is what is named in their statement or their IDP, then you are going through the exact same process as what we set out in the previous slide, which is a written notice to the head teacher of the mainstream school to say you're deregistering your child for the purposes of elective home education, and they will then notify the local authority. You do not require permission, essentially. However, if your child is registered at a specialist school, so not a mainstream school, if your child is registered at a specialist school, and that is named in their statement or their IDP, then permission is required. You cannot automatically request deregistration and that will be agreed. You will need to be contacting the head teacher to say, actually, I want to deregister for the purposes of elective home education, and that's likely going to incur contact from the local authority to discuss the proposals in respect of elective home education and the nature of that provision. In either of those situations, whether or not your young person is attending a mainstream school or a special school, but as long as they have a statement or an IDP, whether you choose to leave them in the school system or you decide to go down the elective home education route, all of the rights and responsibilities that attach to the statement or the IDP remain. So if you are electively home educating your child and they have a statement or an IDP, there should still be an annual review of the statement. There should still be a review of the IDP. You will also have all of your rights of appeal to the Welsh Tribunal in relation to any challenges or disputes that you've got regarding the content of that IDP, of that statement. So it's not a case of your young person would lose those rights, or you would lose those rights, or indeed you would lose the statement or the IDP by choosing to electively home educate. You can have an electively home educated young person that has a statement or an IDP. Can we go forward, please, Kate? What I've set out for you here is actually a proposed outline of contact in relation to an elective home education scenario. This is taken directly from the Welsh Government guidance. I think it's important to highlight that because it shows really what the expectation in terms of best practice would be, particularly on the part of local authorities, the level of involvement and investigation into an elective home education scenario. So if I can just give you a walk through that, those first three boxes at the top of the screen essentially describe that process that I talked about of a parent choosing to electively home educate, writing to the head teacher who notifies the local authority, and then the local authority making written contact with the parent. And the expectation would be, it's not a requirement, but the expectation, because as I say, this is taken from guidance, so we're talking best practice, would be that the local authority is making an offer of either a meeting, a discussion, to go through what the parents' proposals are in relation to elective home education. There is then the choice, coming back to that keyword of choice and choosing in relation to elective home education, of whether the family or the parent agrees to have that meeting with the local authority. It's not a requirement for you to have a meeting with the local authority. You could choose to meet with the local authority. And so that will go down to the right-hand side of this flowchart. So if the family agrees to meet with the local authority, that meeting then takes place, one would hope it'd be quite an informal basis, but you'd want to be putting forward really details and information about the kind of program that you'll be following. So again, going back to what we talked about earlier, as an elective home educator, you're not required to follow the national curriculum. You may be choosing to follow that, in which case in that meeting you might want to give that information. Alternatively, if you've come up with your own programme of education, then at that meeting is where you'd be putting that information forward too. You might, for example, put forward a proposed timetable, details of the subjects that you'll be covering, and that doesn't have to follow a typical school day of 9 to 3, Monday to Friday, of 50-minute lessons with breaks and lunch times. You might have you might start later in the day, you might finish later in the evening, you might have blocks in the day where you're not doing work, and it might not be a Monday to Friday schedule, it might involve weekends as well. But having some sort of record in terms of showing that there's some structure to what it is that you're providing, I think will be really useful in terms of satisfying the local authority that what you're providing is suitable. The local authority then, in terms of this being something that's being set up at this point, might suggest that there's going to be a progress review within, say, 3 months, on the basis that that's the initial rollout period for your elective home education programme. They then make contact with you 3 months or whatever period it is that you've agreed with your local authority that you will have contact with them to say, how's it going? And you would then look to provide evidence of how your young person's getting on their elective home education programme. As to what that evidence is, it's not prescriptive. So you might have video recordings of the activities that you've been doing. You might have copies of work that you've done that you might submit. You might even have a conversation with the young person. You might arrange with your local authority that they can come in and have a conversation with the young person. It's really about working to what the young person is comfortable with, what you are comfortable with, in terms of this is your choice, this is your education programme with your young person. But equally just needing to balance that with making sure that you are satisfying the local authority that what you're providing is suitable and based on all of those requirements of being suitable to age, aptitude, ability. One would hope that your local authority is going to see that the progress is satisfactory and then just arrange a regular checkup. As to what that regular checkup would be, I would say no more than 6 to 12 months, really. There shouldn't be anything more frequent than that. Unless there was cause for concern. Again, none of these time frames that we're talking about are set out in law. So a lot of it comes down to the individual circumstances of the situation. But if a local authority is satisfied at that initial point that the progress that young person's making is satisfactory, then I would say certainly 6 to 12 months is more than sufficient, and doing it on that basis of you perhaps producing almost like a small pack of information showing what the young person's working on, how they've been getting on, will allow the local authority to continue to meet those duties that are on them that we mentioned on the previous slide, of making sure that education for their young people is suitable and that they are actually receiving education. There's a slight breakdown on the right hand side of what happens if the progress isn't satisfactory. And that's where your local authority is going to, as we said earlier, get in contact with you to raise those concerns. But it's not simply a case of a local authority saying, we're not happy with progress and we are going to secure a school attendance order. It should be a staged process that they are going through. That is to contact you and say, we have concerns, we will carry on working with you. So it may be that your local authority draws up an action plan with you and says, okay, well, over the next 3 months that we said, having those agreed timeframes, over the next 3 months, we expect you to take X steps, and then we'll come in and reassess it. I don't know if anybody else can see, but the bottom of the slide, Kate, is chopped off for me, but it might just be because of the layout for me. But if you see underneath the concerns remain when the PowerPoint is circulated, if the concerns remain after doing that level of investigation, that's where your local authority may well look to go down the school attendance order route. Okay. On the left-hand side, it's where we're talking about a family not meeting the local authority. You can't be penalised for not meeting your local authority. You may want to offer an alternative way of evidencing what education programme you're going to be putting forward to your young person. The difficulty really is going to be, and the local authority is really going to become increasingly involved, if you are not engaging with them at all. And that's really the big practical point that I would say to you in terms of having an ongoing relationship and ongoing input from your local authority. You can expect that to happen with elective home education because your local authorities are required to do that. As to how intensive that is going to be is going to come down to how engaged you are with them. That's not to say that it should be put upon you. They shouldn't just be turning up unexpectedly, making those spontaneous visits, knocking on your door, asking for access to your home. But equally, I think if your local authority are seeking to have meetings or discussions with you or asking you to evidence the progress or the education package you're delivering, if you're not going to engage with that, then that's going to cause your local authority to become more and more involved in terms of making contact with you. Okay, then that really concludes an overview of elective home education. Beth, I think at this point I'm going to pass over to you to talk about the new additional learning needs system and elective home education or non-school attendance issues.
Yeah, brilliant. Thanks, Gov. Yes, I'm going to do what I can with the time that I've got because I'm conscious that there's so much to cover here. So there will be a fair bit of signposting, I'm afraid. But as Gov said, you know, any questions, please do pop them in the chat, and we'll try to cover them off by email through Kate after the webinar. But just to give you sort of a general introduction to the new system. Now, I did a webinar for Contact in November last year on this in quite a bit of detail. So the whole webinar was dedicated to the new system. And so if you have sort of specific questions around that, I recommend that you go back and watch that. And also the day after I did that webinar, the implementation guides were produced by the Welsh Government. So we have those as well. If you have a look for those, I think Kate may be able to post the link for you as well. Then that will give you a lot more information about sort of specific questions around the new system. This sort of specifically focuses around home education and what is known as education otherwise than at school or education other than at school. And I'll come on to the distinction shortly. But yes, very whistle-stop tour. So the Additional Learning Needs and Education Tribunal Wales Act was passed by Parliament on the 24th of January 2018. There is, as Gov said, a phased implementation from the 1st of September last year over 3 years. So we've got the two systems running in parallel until 2024. As I said, we've now got the implementation guides, which are helpful, and they really deal with questions, frequently asked questions and transition arrangements between the two systems as well. But the essential point is that SEN or children who had School Action Plus and statements under the previous or existing system will gradually be replaced by individual development plans, so IDPs. And the idea is that everyone in Wales with additional learning needs, or ALN as they're referred to, will be entitled to an IDP. And that's obviously different to the current system. Not everybody with SEN gets a statement. There is this sort of fragmented system where some children have School Action Plus, or the equivalent Early Years Action Plus, or a statement. And now it will bring it all under the umbrella of an IDP. They will sort of vary in complexity. And there are other sort of different duties, some on maintained schools and further education institutions, some on local authorities. Again, I deal with that in a lot more detail in my previous webinar. But you can also, the other key difference is you can have an IDP up until the age of 25. That doesn't mean that it will always be in place until the age of 25, but the local authority would have to actively take a decision to cease to maintain, as is the system in England, and you then get a right to challenge that decision. So it's hopefully pulling everything together, bringing it all under one document and making those rights clearer and more enforceable. And as I said, those duties on maintained schools, further education institutions and local authorities, and it depends on your child's circumstances, who those duties fall upon. Next slide, please, Kate. Okay, so just broadly, this is the definition of additional learning needs. So it replaces the term special educational needs. That's section 2 of the Act. I don't propose to go into this in too much detail. As I say, it is covered in a lot more detail in the previous webinar, but essentially a child has ALN if they have a learning difficulty or a disability, whether that arises from a medical condition or not, which calls for additional learning provision. And then the ALN code, which is the code of practice which accompanies the Act, summarises the test. And it's, do they have a learning difficulty? And that means a significantly greater difficulty in learning than the majority of others of the same age. Or do they have a disability, and does that disability prevent or hinder them from making use of facilities for educational training that are usually or generally provided for others of the same age in mainstream maintained schools or mainstream further education institutions? And if so, does that child's learning difficulty or disability call for additional learning provision to be made for them? There is a helpful glossary in Chapter 1 of the ALN Code, and Chapter 20 contains guidance on identifying ALN and deciding upon the additional learning provision required. Next slide, please, Kate. So this is just a quick definition of additional learning provision. It means educational or training provision additional to or different from that generally made for others of the same age in mainstream maintained schools across Wales. So that's your test. For a child under 3, additional learning provision means educational provision of any kind. So that just gives you an indication. So any child who meets that definition and has additional learning needs for the purposes of the Act has a right to have an IDP. So just coming on to how that sort of works in the context of the new ALN system. So education otherwise than at school, so EOTAS, this is separate and distinct from elective home education. This is where, in law, local authorities are responsible for providing services for education for these children. So the Welsh Government EOTAS framework, which hasn't been updated following the introduction of the new Act, but it says that EOTAS is education provision to meet specific needs of pupils who, for whatever reason, cannot attend a mainstream or special school. And in law, local authorities are responsible for providing these services. So for whatever reason, a child or young person can't attend a mainstream or special school, you know, they may be in hospital for a prolonged period, they may be accessing education in a pupil referral unit, which is a maintained school for the purposes of the Act, but is also classed as EOTAS. Or they might be receiving education at home because they cannot access education at school. And if they have additional learning needs, they will be entitled to an IDP as well. So first of all, if your child has ALN according to the Act, they're entitled to an IDP regardless of where they're educated. So in terms of transitioning to the new system, the system started to go live for those children who are newly identified as having additional learning needs from September last year. That's up to and including those in year 10. But it's those who don't already have School Action Plus or a statement. Children who already had identified SEN, so School Action Plus, but not statements, are being moved from the SEN system to the ALN system in groups on a phased basis over the next 3 years. So that depends on which year group they fall in, and the implementation guides give further detail on that and some quite helpful tables to work out where your child falls. But during this school year, so the 2021 to 22 school year, a parent or child can request to move to the new ALN system if that child has School Action or School Action Plus currently as of 1st of January. And if they attend a mainstream, a maintained nursery, maintained school, or a pupil referral unit up to and including year 10. So for children who fall within that remit, and as I say, I cover this in more detail in my previous seminar, you can make a request to the local authority to be moved across to the new system rather than it happening automatically in those groups that are set out. But children who are in receipt of EOTAS or who are electively home educated as of the 1st of January will not move to the ALN system in the first year of implementation. So in this year, they will not be moving across, they will stay in the previous system. We will await further guidance on how that transition will work for those children. But what I've tried to do is just set out what the Code and Act say about what will happen when those children do move across to the new system. So what will EOTAS look like under the new system? So Section 19(1) of the Education Act 1996 the duty remains. Each local authority shall make arrangements for the provision of suitable education at school or otherwise than at school for children of compulsory school age who by reason of illness, exclusion or otherwise, and that's important, may not for any period receive suitable education unless arrangements are made for them. Sorry, Kate, I should have said move on. Thank you. Section 19.6 defines suitable education as Gov has touched upon as efficient education suitable to the child's age, ability and aptitude, and importantly again to any ALN they may have. So this is distinct from elective home education where the parents are choosing to home educate their child. They could attend school, but it's an active choice to do that. Local authorities have a power but not a duty to make EOTAS arrangements for young people, so for people who are over compulsory school age but under 25. And just to signpost there as well to chapter 18 of the ALN code for Wales 2021, which deals with the EOTAS in detail, and it deals with how it applies to different groups of children and children in different circumstances as well. So that's worth having a look at. Next slide please, Kate. So section 53 of the new Act deals with additional learning provision otherwise than at school. So it says that a local authority may arrange for additional learning provision in an IDP it maintains for a child or any part of that additional learning provision, and again that's important, to be made otherwise than in a school, but it can only do so if it's satisfied that it would be inappropriate for the additional learning provision to be made in a school. And the code also recognises that in the case of a child educated through EOTAS who's not at a PRU, the range of professionals involved in the IDP process might be wider and in some respects different from those professionals involved where a child attends a school. And I think, you know, that's just reflecting the fact that these are very sort of bespoke arrangements and they're individual, you know, to what that child needs. And it recognises that, you know, it's not a one size fits all approach at all. Next slide, please, Kate. So how will a tribunal decide if it would not to be appropriate for my child to be educated in a school? Now, this is a case which gave guidance in the context of the English legislation, but albeit it largely applies the same test. So the tribunal must ask whether it's satisfied that it would be inappropriate for any special educational provision or additional learning provision that is decided as necessary for the child. So which is in, you know, part 3 of the statement or the equivalent section of the IDP, to be made in any school and for any part of the provision to be made in any school. And in considering whether it would not be suitable, they take into account all the circumstances of the case. So the child's background and medical history, their educational needs, the facilities that could be provided by a school, facilities that could be provided other than in a school. It says comparative cost of possible alternatives. I think I sort of question that slightly in that, you know, if it's not suitable for them to be in a school, you're not then taking into account the comparative costs because there is no alternative. But, you know, there are some circumstances where it may be relevant that there are different options available. Parental wishes, although they're not determinative, but they are important to take into account. And then any other particular circumstances that apply to that particular child. So essentially, if a child's needs are such that it would not be appropriate for them to attend school to receive any of the additional learning provision that they need, then EOTAS should be provided, and it is the local authority's duty to secure that provision in the statement or the IDP. Next slide, please, Kate. Thank you. That was just a quote from the ALN code. So again, just reflecting that a child or young person may be ill or injured or have been excluded. And the examples of the EOTAS provision include pupil referral units, schools established in hospitals, further education institutions and individual tuition at home. And again, the code emphasises that it's different to elective home education. So if your child has EOTAS, but they don't currently have an IDP, but you think they may have ALN, who decides that? So again, it's slightly complicated in that it depends on the circumstances. So a pupil referral unit, as I said, is a maintained school for the purposes of the ALN definition. If a child has EOTAS within a PRU, then it's the management committee of that PRU that has responsibility for deciding whether that child has ALN. And it does that where it comes to their attention or otherwise appears that they may have ALN. So basically, if it comes to the PRU's attention that the child may have ALN, however it comes to their attention, they then have a duty to decide. And Chapter 12 of the ALN Code deals with those duties in more detail. If a child or young person has EOTAS other than a PRU, it's usually the local authority's duty to decide whether the child or young person has ALN. Again, if it comes to their attention or otherwise appears that the child may have ALN. I deal with these duties in a lot more detail again in my previous webinar, but it's to signpost as to which body is going to have responsibility where a child has EOTAS, or you think your child may have ALN if they have EOTAS. Chapters 13, 14 and 17 of the ALN Code deals with the duties on local authorities in this regard, so it's worth having a look there. And then also if it's a looked after child, so a child looked after by the local authority, again it's the local authority's responsibility to determine if the child has ALN, and then to prepare and maintain an IDP if they decide that the child does have ALN. Next slide please, Kate. Okay. So where a child is receiving EOTAS because of healthcare needs, what will happen under the new system? So the ALN Code signposts to the Welsh Government statutory guidance on supporting learners with healthcare needs, and that's in relation to arrangements made by maintained schools and local authorities for supporting learners under the age of 18 with healthcare needs. Section 175 of the Education Act 2002 places a duty on local authorities and governing bodies to make arrangements to ensure that their functions are exercised with a view to safeguarding and promoting the welfare of children in school or another place of learning, and that includes children with healthcare needs. And then Section 21(5) of the Education Act 2002 places a duty on governing bodies to promote the well-being of learners. Section 25(2) then sets out what matters governing bodies must take into account in promoting the well-being of learners, and that includes physical and mental health, emotional well-being, education, training and recreation, and social well-being. So this guidance is very helpful. It recognises that there needs to be consideration given to flexible delivery of the curriculum to help learners reintegrate within an education setting during periods of absence. So for example, through part-time study or alternative provision from the local authority or phased returns. Local authorities should also ensure that education provision is available to learners and should work with education settings to ensure that children with healthcare needs receive a suitable education. And it says that where a learner of compulsory school age would not receive suitable education for any period because of their health, the local authority has a duty to make arrangements to provide suitable education. Again, coming back to that Section 19 duty. And if they're over compulsory school age but under 18, then it may make such arrangements. Paragraph 2.10 deals with the EOTAS specifically. And it says that, they may receive support during a period of illness if they're in hospital, a PRU, or at home. And then it importantly makes a distinction between a short absence. So if a child's out of school for less than 15 days, then the learner's school should generally provide for work to be completed at home if their condition permits. And it says that local authorities should be ready to make arrangements for learners in cases where it's clear that their absence is likely to last for a significant period, which it says, for example, would be more than 15 school days. But it also recognises that that's not sort of set in stone. That's just guidance. Local authority might still need to make arrangements if a shorter absence is anticipated, depending on the circumstances. It also says that where absences are anticipated or known about in advance, there should be close liaison by the school, between the school and local authority.
Sorry, Beth, can I just check which slide we're on?
Yeah, sorry, I'm going into more detail on the supporting learners with healthcare needs guidance, but I didn't put it in my slide, so I was just fleshing out on that. It's slide 17.
Is it the my child is receiving EOTAS because of the healthcare needs?
Yeah.
Okay.
Yeah.
Sorry, everybody, I went forward too quickly.
No, sorry, that was my fault. So that was, yeah, it's just to give you kind of the key parts of that guidance and what's expected. So that will continue to apply. Hopefully it will be updated, because at the moment it doesn't reference the ALN code, but the ALN code references that guidance. So that's a good place to start if your child has healthcare needs and you know, isn't able to access school currently. So the same duties apply under the new Act to children and young people who have healthcare needs. So for whatever reason they have an interruption to their education because of an admission to hospital, so including compulsory admission under section. The code goes into more detail about what is expected. So if the child's in hospital for a sustained period, it says that it may be appropriate or necessary to review their IDP, and that just recognises that there's, you know, possibly a change in circumstances. If a school is maintaining that child's IDP, it may be appropriate for the local authority to take over responsibility for maintaining that IDP. If, however, that child or young person will be returning to mainstream education following a prolonged absence, it might be appropriate for the local authority to then direct the school to take over maintaining the IDP, or for it to be reviewed in light of a change in circumstances. I think it becomes quite complicated because it feels like there is quite a lot of potential for, you know, it not being clear who's responsible, and there's a lot of, oh, it may be appropriate, you know. I don't think that's particularly helpful, and we haven't seen this working on the ground yet. So it's yet to be seen how this is going to work in practice. But, you know, I think go back to the code and see what it says, and really it's just making sure that you're in you know, close liaison with the school and the local authority where a child's having an absence due to healthcare needs. Okay, next slide please, Kate. Okay, so if you've got a child who's no longer on the school roll, but they have an IDP and they're having EOTAS, what should happen? So if the child has an IDP and it's maintained by a maintained school, but then they cease to be a registered pupil at that school, the school's duty to maintain the IDP will fall away. And the code says it, then the local authority is likely to be subject to a duty to decide whether the child or young person has ALN. And if so, the duties will be on the local authority to prepare and maintain an IDP. I don't think, again, the terminology is likely to be as particularly helpful. But if, and again, it also seems to suggest that where a child's had an IDP previously maintained by a school, but then a local authority takes over, the process starts again, and the local authority has a duty to decide whether the child or young person has ALN. What the code does say is that the local authority ought to be able to do these things fairly quickly in light of the child having a previous IDP. And it says they should take into account that previous IDP and other related information where available. Unless circumstances have changed significantly, this ought to enable swifter decision making and a new IDP that is prepared more quickly. If the child or young person becomes a registered pupil at PRU, then the PRU's management committee will become responsible for the IDP. A child with the EOTAS may remain a registered pupil at school that was maintaining an IDP, but if they become dual registered, so if they become registered at a PRU and at a school, then the local authority becomes responsible for maintaining the IDP. And as I said, all of this is dealt with in a lot more detail in my previous webinar in terms of what those duties actually mean and translate to. So it's worth having a look there if you're sort of confused about how this is going to work in practice. And
that's really helpful, thank you. Sorry, just on that point, a number of the queries that we've had come in actually relate to this issue of elective home education IDPs, but also in relation to payments, maintenance arrangements. So I'm just looking down at my notes here. Schools saying that children aren't going to be getting IDPs, queries about who's funding the IDP. I think all of those, correct me if I'm wrong, Beth, are issues that are covered in your previous webinar. The link to that has been put in the chat, Kate. I don't know if post this session we could look to recirculate that to the attendees today, but it sounds like that's something that if we can arrange for that to be done, If we can just jump to the last slide, if that's all right, just because from the chat I've been asked for contact details. They are on the end slide here for ourselves, because I think what I'm picking up is that there is a real confusion in terms of the new system of ALN and IDPs with non-school options, whether that's elective home education or RIOTAS, Beth. And I think some of them require some individual support in terms of advice. The contact details are there. Please get in touch with us and send those out. I've said in the chat that I will be putting together a response to some of those questions. But as I say, a lot of those questions have been answered in Beth's previous webinar. Just on the point, there was one question about, can a local authority use elective home education to avoid a particular education technique, specifically ABA? Absolutely not. Well, not least because, I mean, the way it started is, can a local authority use elective home education? Go back to what I said at the beginning about elective home education being parental choice, absolutely not being available as an alternative education option for a local authority. It's your choice as parent. If you are going down the ABA route and wanting to incorporate that into your elective home education programme, that is your choice. Equally, if you're wanting to look at securing ABA through the IDP or the statement, then that can be pursued. You need to look at a slightly different criteria in terms of getting it written into one of those documents. What I'd like to suggest to that individual is that you look at getting in contact with us directly. It's just something that we'd need to discuss with you individually to explore that. I'm really sorry to have brought it to a close at this point, but I'm conscious, Kate, that we are at our allowance of time in terms of being able to circulate this and making it available for other people. But just to reiterate that questions won't be ignored. I'll put the response together and get that out to you through Kate. And if you've got any other questions, Kate, I don't know if you want to offer how people can get that to us.
Yeah, certainly. Everybody who's on the session today will be getting a copy of the link. They'll get my email, and I will include everything. I'll include the slides, a link to the recording, and also the responses to the questions and contact details for Irwin Mitchell. And I'll just move on to our last slide, just to let you know about contact very briefly. We do have a helpline. You can contact the helpline for any issue that you might have. The helpline is, I'll pop the number in the chat in a minute, but it's 0800, sorry, it's not 0800, it's 0808 808 3555. But we also are able to offer you a listening ear, one-to-one appointment with one of our family support consultants. We offer free workshops. We have tons of information. So I will be sending this by email to everybody. And you can contact me as well at any time at all. And I'd just like to say thank you to everybody for attending today. And especially thank you to Irwin Mitchell, Gov, Beth and Nicole for offering to do this webinar for everybody. It's just so incredible that you're able to do this. It's an invaluable resource to parents. And I hope for everybody watching, there's a lot of information to take in. When you do get the recording, you can stop and pause it and read the slides and really take it at your own speed. And as Beth said, for more detail about the ALN side of things, we do have the webinar that she's provided. So thank you everybody for today. Is there anything that I need to add?